I'm Jerusha Sukhthio-Rath and you're watching News 24 Live. Now, public hearings into the amendment of the Sexual Offences Act of 2007 have wrapped up in Parliament. Advocacy groups are calling for the decriminalization of sexual acts between adolescents of the same age. I'm joined in studio by RAPCAN's Christina Nomdu. She's part of the advocacy group and she's going to speak to us a little bit more about the public hearings. Christina, thank you so much for joining us today. Now, won't you tell us a little bit more about what the current Sexual Offences Act says?
I think that RAPCAN became involved in the Sexual Offences Act processes when we noticed that Section 15 and 16 of the Act that deals with consensual sex between adolescents seem to infringe on the rights of adolescents. And so we took this matter up in court, first in the High Court and then in the Constitutional Court. And the Constitutional Court found, yes, that children's dignity, privacy rights and the best interest of the child was not being served by the current provisions in Section 15 and 16 of the Sexual Offences Act.
So what does
adolescents of the same peer group, 12 to under 16 years old, and in fact the current Act criminalizes sexual behavior between adolescents.
So at the moment, a child, two children, or two adolescents who are in a consensual sexual relationship could have serious implications by way of their names being put onto a register, for example. What are the implications of consensual sex between two children between the ages of 12 and 16?
So I think that what concerned us primarily is criminalization brings children into very close contact with the criminal justice system, which means that they are questioned by police and they are almost asked. And so firstly, our main opposition was around the harm that the criminal justice system can have on the child. You will remember the Jules High School case, which really brought this into stark reality for us, where three adolescents were involved and it later transpired that it was consensual sex, but they had to go through a diversion program in the interest of the child.
But you do have groups who oppose what you are pushing for, and that's the decriminalization of sex between adolescents, who say that this isn't going to help young children. It's going to encourage people who are perhaps not mature enough or who don't understand the implications of what they're doing to go ahead and have sex. But you don't believe that to be the case?
I think we must say from the outset, we as an organization, even as a group of advocacy organizations, are not promoting sexual activity at young ages. We do not think it's advisable. But we also don't think it's advisable to criminalize adolescents for this behavior. So somewhere we have to put the responsibility for maybe shaping adolescent behavior somewhere else. And for us, it is in the purvey of parents, supported by their faith-based institutions, to build a value system with adolescents when they make decisions around life-changing behavior, including sexuality. I think also another part of the Act served to criminalize adults. So a parent who knew that their adolescent was engaging in sexual behavior, if the adolescent came to ask for advice from their parent, the parent was mandated to report this or even face criminal sanctions themselves. And this is another aspect that the Constitutional Court found to be untenable, because it said it created a break in family. For you to separate a child from their parental guide created a break in family. And so this also they did not feel was in the best interest of children.
I think it's important to note at this point that no advocacy group is calling for the decriminalization of sex between an adult and an adolescent, an adult and a minor. That, in your eyes, the eyes of your institution and the advocacy group, is still a crime.
Yes, and also I think we must say that the age of consent remains 16 in the old Act, and even in the new law that we'd like to see. We would like to see that unchanged. So this issue or this application to the court is not around changing the age of consent for sexual behavior. It's also not about non-consensual acts between children. So if there is coercive sex between children or adolescents, this should definitely still be a crime.
There's so much to discuss on this because, Christina, when you joined us previously, we spoke at length about the criminalization of children in South Africa and how it's incredibly unhelpful to them. So let's touch on this first. I think we've got so many issues to talk through. Let's start with this. In the event of a criminal act, a criminal sexual act by a child on a child, there needs to be some type of recourse, and you're saying that you don't want that to be de-legislated. But what would be the idea?
Remedial action does not fall within the purvey of the Justice Department, because the Justice Department's mandate is to create crimes. And so we're saying that we need to be having this conversation with the Department of Social Development, the Department of Health, and the Department of Education to really come and fulfill their mandate in supporting children to make positive life choices. So within options around pregnancy even. So we need to find a more supportive system in the health system. We need to find school-based curriculum around life skills orientation that really goes deeper than just the plumbing of sex, so to split. I think I said in the public hearings, when we hear sexuality, then we think sex. And sex actually is quite a very specific part of sexuality. We're calling for the support of adolescent sexuality in the broad sphere. So social development programs that do prevention and early interventions. There is a role for that from government side. But the primary role in relation to guiding children around their sexual choices, adolescents in developing their sexuality, is from parents, we believe.
Now, you've spoken about the responsibility of parents, social development, and even the health system. Let's go to the actual Act 2007. Want to see that legislation changed too.
So because the initial legislation, now the 2007 legislation created a crime, the next law will have to decriminalize, so make that crime not exist on the statute books any longer. And also we're asking for further protections of the entire sphere of childhood, because even though the age of consent is at 16, we don't want to criminalize 16-year-olds who have peer relationship with 15-year-olds. So we're asking for a close-in age defense with 16 and 17-year-olds, so that the entire category of adolescents is safeguarded in relation to criminalization for peer relationships.
Now, there are detractors, and you've touched on it briefly, but I want to speak about it in a little bit more detail, who are saying, but Christina, I do not want my 12 to 16-year-old having sex, and perhaps the only way to do this is to frighten them by letting them know that actually what you're doing is a crime. Now, having spoken to you before, I know that you don't believe that fear is any type of way to get children to do anything. But I think that it's certainly being leveraged in our schools and in our families by telling young kids, or adolescents even, listen, if you're going to do that, that's a crime.
I think that there is an orientation around what was intended by the Act was to create a deterrent.
Yes, yes.
And I also spoke last time about my belief in evidence-based information. So I don't think that there is any evidence information that leads us to believe that criminalizing, instead we hear levels of teenage pregnancy or adolescent fertility rates are dropping in this country. So this, these ostensible dangers, alleged dangers that we are talking about in relation to adolescent sexuality. HIV incidence rates in adolescents is dropping. So we can't use this fear-based response. It's not going to help the situation. We need to become more proactive and involved in the lives of our adolescents.
Speak to us about the advocacy groups. Who was involved in these public participations? Sure. Quite a few people, I'm sure. And why don't you just give us an overview of how things went?
Yeah, I think that at the first, there are many advocacy groups that we join hands with: the Children's Institute, the Community Law Center, the Center for Child Law, the Teddy Bear Clinic. Those are key organizations that we collaborate with in order to build a strategy for law reform from a rights perspective. The first day of the public hearing saw the applicants in the Constitutional Court case. and the respondents, the amici for the respondents that is about, so that we could understand what that order from the court was. The second day was a bit hard for me to survive, because you had quite vociferous faith-based organizations that called human rights defenders, and I quote, agents of Satan and forces of darkness. So, you know, we as human rights defenders, we sort of sat back and thought, you know, are we not in the social contract together in society to build a constitutional democracy, a participatory democracy? And it really had some effect on us. The third day happened in the next week, and there you had a lot of evidence-based organizations from academic circles coming to the fore. Dr. Annick Geevers, for example, who was the expert who advised our application to the Constitutional Court. Professor Anne Skelton, who was the representative of Teddy Bear Clinic and RAPCAN in the court case, brought really an evidence base around why we believe adolescent sexual behavior is normative. Dr. Annick Geevers has done lots of empirical studies in this country. And that's why we talk about evidence-based decision-making. We need to not respond to our fear and our inhibitions. We really need to respond to the reality out there. On the fourth day, I think there was a lot more reflection, and that day was really rounded off really well by children from Molosongololo, who came to speak about how they would like to be supported in their sexuality, how they believe the role of parents is integral, educators are integral in that kind of guiding, that they don't want to be, the information really needs to be something that is helpful to adolescents and not just fear-mongering. So don't do it. Abstinence-only programming and messaging has not found any evidence base anywhere in the world. So we have to shift our responses to the issues that we find concerning in our society. And we argue we do this by rebuilding that relationship between parents and children.
Christina, did you find that many of the people who were opposed to what you are asking for did come from religious-based organizations, or who are you speaking to? Who are the people who decide that, or who believe that this isn't the right way to go?
You see, I think that we share a lot with those sectors of society as well. We also believe that there should be a values base, a morality that we should transfer to our adolescents and children. So I don't see that there's so much disconnect between the orientation of faith-based organizations and ourselves. We see a strong role for the faith-based sector in supporting parents to do that job. I think that, you know, people become a little bit excited in presentations, and we take that, you know, as just opinions of difference, which makes our country so marvelous, that you have to have opinions of difference so that you have a nuanced approach to the realities that exist.
Speak to us about what will happen now. So we know that the public hearing portion of this process has been concluded. What happens now? Next
week, the Portfolio Committee on Justice and Correctional Services have scheduled deliberations. So we are coming closer to the point where the actual wording of the new bill will be crafted, and then this new bill will be put before Parliament, the National Assembly, to ratify as the new Sexual Offences Act. It's called, in fact, and the Molosongololo children highlighted this, the current act is called Criminal Law, Sexual Offences and Related Matters Act of 32, 2007, and the Molosongololo children said, please make the act's name shorter. It's just not manageable for us to so, because it covers so much more than just these two provisions, you know. So, but we're focusing in our advocacy efforts on sections 15 and 16 of the current act.
Realistically, if this does go through the National Assembly and is ratified, when can we see this legislated, and when can we see this in effect in the country?
So the Constitutional Court was actually quite strict about creating that framework. They said that this law should be in effect by April of this year, 2015. That is not for administrative reasons, that's probably not going to be the case. And I think Parliament has made it public that they are asking for an extension from the Constitutional Court. So we're looking at a time frame in relation to August of 2015. And that's when we expect a new law definitely to be in place.
So this is certainly not something that government or even Parliament can drag their heels on. Hopefully we're going to see change this year.
There's a Constitutional Court order.
Christina, thank you so much for joining us today.
Thank you very much for having me.